Hello everyone. Good evening.
Good evening.
Yes, good evening. Can you all hear me?
Yes, I believe so.
Yes,
Yes.
we can hear you.
Progress. Yes.
Please, if you can hear me, please confirm that you can hear me.
I can hear you here. Others can hear you. I can hear you.
I can hear you.
There's an echo though.
Yes, there's an echo on the background.
All right, please give. Please, I'm trying to sort out an issue. Give me 1 moment to sort that out, and I'll be right back with you. All right, please confirm now that you can hear me. If you can hear me.
I hear you.
Yes.
All right, thank you very much. Good evening, everyone. Welcome to our first official class for this quarter mentorship. My name is Dennis Williams, and I'll be your moderator for today. It's nice having everyone in class. Please, can we have our videos turned on if that is possible? I would like to see those that I'm interacting with or those that we are having this class together with. Please kindly turn on your video camera. Thank you very much. Thank you very much, Jesu Tofumi. Sorry if I did not pronounce your name very well. So once again, welcome to our first official class for the JIIPCC Mentorship and Internship Program, Alternative Disputes Resolution. We'll be going shortly into the what we have for today. All right. This particular program that we are hosting under the Alternative Dispute Resolution is brought to you by the Gypsy Academy in collaboration with the Settlement House ADR Teaching Institute, right? So they with us to bring over this course to you, right? So please, I would like for us to over the course of the next 7 weeks. So far, registration already for the next quarter is already ongoing, right? Please, if at all you want to register or you have someone that is in registering for our program, kindly reach out to me and I'll do. People can start registering ahead of the next programs for today. The people who will be taking us through on the journey of our topic for today, which is an overview of ADR. And first mentor for today is going to be Miss, sorry if I didn't pronounce that name very well, Marunian professional, specialized in international arbitration, mediation and consultancy, with an extensive academic background an LLM, an MSc, and an ongoing PhD study. Ms. Parr holds several prestigious of arbitration, a fellow at the International Mediation Campus in Germany, and ICCYAAF member. Currently, Ms. Parr serves as an associate arbitrator at Ames Capital and Associates Limited. in Kigali, Rwanda, and manages the operations of the Chartered Institute of Arbitration in Rwanda. She is also the founder and the CEO of Voice of Cameroon Women International and holds key leadership roles in several organizations dedicated to youth empowerment and development, including Cameroon Youth for Justice and Freedom and Friends of Africa Developments, Friends of African, sorry, um, Friends of Africa Development Association. Consultancy works work MISPA's consultancy work focuses on advising investors and companies on corporate social responsibilities and prevent conflicts and disputes. Her strategy, insights, and deep understanding of business dynamics has made her a consultant in investment and commercial transactions. In addition, she's a board member of the Equal Trade Women Alliance and a representative of the African Arbitration Association in East Africa. In recognition of her contribution, MISPA was named one of the 50 Power People in Africa by the ELOY Foundation and the African Women CEOs Network in 2024. She is also a citizen public speaker, regularly sharing her expertise at national and international conferences on topics such as business strategy, gender equality, and environmental sustainability. MISPA's extensive certifications and training further underscores her commitment to professional excellency and her role as a leading advocate for justice, peace, and development in Africa. Thank you so much, Miss Mispa. A very, very powerful profile from our end. I'm sure if I'm not mistaken, she's already on call. Miss Mispa is our first mentor for today. The second mentor that we have for today is Miss Eunice Olatunji. Miss Eunice Olatunji is an accomplished legal professional and the lead counsel at Hepzibah LP Lagos, Nigeria, with expertise in business analysis, negotiation, mediation, and general dispute management and resolution. With nearly 2 decades of experience as a legal practitioner and a decade as an ADR practitioner, Eunice seamlessly integrates legal knowledge with business acumen to provide holistic solution. She holds an MBA from Obafemi Awolowo University, Nigeria, and a master's in mediation and conflict resolution from the University of Strathclyde, UK. Eunice is a notary public notary public of the Supreme Court of Nigeria, member of the various professional associations, and a pioneer member of the Standing Conference of Mediation Advocates Nigeria. She is a certified restorative justice facilitator, trainer, peace educator, and service on the panel of neutrals at the Lagos Multidor Court House, Kaduna State Multidor Court House, and the Mediation Clinic, Strathclyde University, UK, and Scottish Mediation Network, where she has successfully mediated numerous cases. She currently works as an individual conciliator at the UK government organization resolving disputes between employees and employers. Eunice is a sought-after international speaker and judge in prestigious mediation competition and conferences. Eunice shares legal insights on her YouTube channel, Legal Solutions with Unique Eunice. Her journey is marked by a commitment to excellent dispute resolution and a passion for educating and empowering others. Down below is Miss Eunice's contact details. The flyers have been sent to your group. If at all there's need for you to contact her, please you can kindly use the information provided below on the flyers, right, to do that. Thank you so much, Miss Eunice. I can see you're already with us. Thank you so much for joining us. Our third mentor for today is Mr. Nachang Namwan. Mr. Nachang happens to be the executive director of the Settlement House ADR Training Institute. Right, Mr. Nachang, right, is part of the those who have joined hands with us to facilitate this particular program, and we are excited to have him with us. So, just briefly to just run through his profile, Mr. Nyacham Nawan is a lawyer and the principal partner of a law firm, N. Nyacham and Co., a law firm based in Kaduna, a certified teacher, trainer, and facilitator. He is a faculty member and the executive director of Settlement House ADR Training Institute and is an institution for the training certification and practice of alternative dispute resolution. He is a member as well as a faculty member of the Nigerian Institute of Chartered Arbitrator, a model arbitration certification institute in Nigeria. He is a certified dispute resolution specialist, an international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR registrar, slash secretary, a holder of Mediation Academy, United Kingdom certificate in commercial mediation accredited by the Institute of Chartered Arbitrators UK, a medical law enthusiast, and elements of labor laws experts, Accords International, Indian, a Florida Supreme Court certified county mediator in the United States of America. For the want of time, I may not necessarily be able to read through his profile so that we can get to the nonetheless, we are in awe of Nyach and Naman. We are happy to always have you around. Much for joining. I think our fourth mentor. Sorry about that. My network got disconnected briefly. Um, sorry.
Okay. So,
Share my screen
good
again.
evening, everyone.
It's
Yeah,
disconnected.
Mr. Iba.
So sorry again, my network is somewhat bad, but I'll quickly run through Mr. Joseph's profile. Mr. Joseph is the team lead at Strain and Blend Partners. Joseph is a team lead at Strain and Blend Partners. He leads the firm arbitration, maritime construction, and energy dispute practice group. He is a graduate of law from the Niger Delta University and the Nigerian Law School. Joseph has extensive experience in arbitration and commercial litigation. He has acted as a counsel in several international arbitration and arbitrary awards enforcement proceedings, other major arbitration rules, including ICC, DIAC, UNCITRAL, MAAN, and RCICAL. His focus is on providing cutting-edge strategies for resolve disputes in areas of maritime, oil and gas, commercial contracts, construction, corporate debt recovery, bankruptcy slash insolvency, and civil fraud slash white collar crimes. He is also experienced in advising clients in relation to concession contracts, joint ventures agreements, maritime assets acquisition, due diligence, and distress situation deals. All right. Thank you so much, Mr. Joseph, for joining us. It's nice having you with us. Our fifth mentor for today is Mr. Samuel Orobosa or Sarenren. Because of how lengthy Mr. Samuel's profile is, I will just be giving a a few highlights on his profile, and then we'll move to our last mentor for today. Mr. Samuel Orobosa Osaren is a mediator, an arbitrator, a peace advocate, a negotiator, and a distinguished ADR practitioner to the core. He possesses advanced knowledge and understanding in peace and conflict advocacy, community mediation, family mediation, workplace conflict management and resolution, peace building, amongst others. He is a minister of God. He holds a PGD in theology from the Redeemed Christian Bible College, a graduate of Word of Faith Bible Institute in the Living Faith Church, a lover of peace and of the youth. Osareren is a graduate of banking and finance from the University of Benin. He has passion for advancing the gospel of ADR, which accounted for his willingness to volunteer and facilitate various means of peaceful and amicable dispute resolution. He is a principal consultant at per Persecuris and Associate Counsels and the founder of Rehoboth Encounters Prayer Group. Um, like I said, the profiles have been sent to your group. Please, you can also kindly read up the rest of Mr. Samuel's profile on your group. Thank you so much, Mr. Samuel. It's always nice having you with us. We look forward to hearing from you as well as our other mentors in today's session. Our last but not least of our mentors for today is Mr. Tohid Amuda. Mr. Tohid Amuda is the founder and managing partner of Law Managing is the founder and managing partner at Lovokate Attorneys, a firm of lawyers, investment consultants, and arbitrators. He is an international commercial dispute attorney and an investment consultant. He has significant experience in commercial litigation, commercial arbitration, and investment treaty arbitration. He holds a Master's of Law degree in this degree with distinction in international business law from the University of Law in London, United Kingdom. He has written a significant number of articles in the dispute resolution space and holds several awards. His experience is multi-jurisdictional as an investment consultant. He regularly assists businesses in raising capitals for their expansion, ranging from equity to venture capital. Thank you so much, Mr. Toid Amuda. Um, Let me quickly run through our through the okay. I can see some of our mentors already here with us, and thank you so much to every member mentee that has been able to join, and thank you also to our mentors that are currently on the call. Not to waste any further time, as we have taken quite a lot in reading of the profiles of our mentors, we would first like to, as it has been our practice since the last quarter of mentorship, to start off with the mentee's presentation. We'll be starting off with the mentee's presentation, and then our mentors will be giving us an oversight of the topic and also be giving feedbacks to the presentations that was made by the mentees, and then we'll be having questions and answers. So please, do we have our presenters in class? Group one presenter, please go ahead and make your presentation, followed by the group two presenter. From there, we'll be hearing from our mentors who will be running us through today's section, and then from there, we'll move further. So, group one presenter, the time for your presentation is now. Please step in and make your presentation. Presentation time is 5 minutes, so please kindly stick to time. Do we have the presenter
Okay, good.
for group
Dennis, good evening.
one on call?
Mr. Dennis, can you
Yes, good
hear
evening,
me?
sir.
Good
Yes, I
evening.
can
How
hear you,
are you
sir. Good
doing?
evening. I'm very
Yeah.
fine, sir.
How are you doing?
Very fine, sir.
Hello?
Very fine, sir.
Okay.
Yes, I said I'm very fine, sir.
All right. Thank you very much for all the introductions and the rest. I don't want to confirm how many of our mentors are here. I can see Mr. Yes, I can see Mr. Amuda. Who else do we have?
Miss Eunice is also on call.
Okay, Eunice is on call. Okay, what of Miss Pa? Miss Pa, are you in the house? Okay, some of them
I
will
don't think
join us
Miss
very
Price
soon.
with us.
Okay, so some of them will join us very soon. Just as Mr. Dennis has stated, we will, in the course of the mentorship, be available to attempt or answer all your questions to the best of our abilities. And then if you have any issue, in regards to some of the things that you need to be doing during the mentorship program, feel free to reach out to us or reach out to me or to Dennis, and then we'll get that sorted out. So before you commence your presentation, I will want to welcome Mr. Amuda. Thank you for joining us. I'm really happy to see you.
Thank you.
Yes,
Thank
sir.
you very much for having me. Thank you for the
Yes,
invitation. Thank you.
thank you. I want to also welcome Ms. Eunice for creating time out of her busy schedule to join us. Please, for the mentees, I want you to take this training very seriously, because this is actually a free mentorship program in ADR, and it covers almost all aspects of the ADR. Some of us never had the privilege or the opportunity to have someone mentor us. Maybe we would have gone far by now, but we had to find our roots. But this mentorship covers from the introduction to almost all aspects of the ADR. And then people who are versed in the field are going to be available to answer your questions. And it is expected that when you are given a task, you make your research and prepare a slide which you are going to present. The mentors are here to be able to guide you and then raise issues and matters that you have left out in the course of your presentation. So we are all learning. I believe that this should be a time for us to learn, to relearn, and to unlearn. So please be open-minded. And the mentorship is done in collaboration with Settlement House ADR Training Institute. And then we have a lot of resources and materials on ground to be able to be of help and assistance. And for some of you who want to, in the course of this training, proceed to become certified mediators or arbitrators, we also have arrangements for you. And there are actually special arrangements for those who want to proceed to become professional ADR practitioners and certified. You have if you are a mentee and then you have concluded your mentorship, you have a special kind of arrangement for you to take advantage of. So please put your best, be committed to it, and at the end of it, I know you will really appreciate that you created time for this mentorship. So having said so, thank you very much, Dennis. Let us allow them to do their presentation.
All right, thank you so much, Mr. Nacham, for helping us with that words with those words. So please, do we have our presenter for Group One on ground? Please go ahead and start your presentation so that we don't waste any more time. One presenter, are you with us? If the presenter is not available, can we have the backup presenters?
Yes, yes, I'm available. I'm available, sir.
Okay. So please, do we have Okay, thank you very much, Ajimoto Khan Daniel. Sorry that if I didn't pronounce your name very well. Please, you can go ahead and start your presentation on behalf of your group. Thank you. Daniel, please, can you hear us? Daniel, please, can you hear us?
Yes, sir. Yes, sir. I can hear you, sir.
Yes. Kindly leave your mic unmuted and please go back to the presentation and just start up with it.
Okay, sir. Can everybody hear me?
Yes, we can.
Good evening. Good evening, everyone. I am Ajimoto Daniel Olaide, the presenter for Group 1, and I will be presenting on the topic an overview of alternative resolution, focusing on negotiation and mediation. Yeah, within the course of my presentation, I will be talking about some things. I will be discussing about the introduction, giving us the introduction of ADR. I will be discussing about the history, the brief history of ADR, the definition of ADR, the negotiation. I will be talking on negotiation, mediation, differences and similarities of negotiation and mediation. I will be discussing on the merits and demerits of ADR, and I will be ending my presentation with conclusion. So to start with, talking about the introduction of ADR, please, if you can't hear me at any point in time, please kindly notify me. Thank you.
Mr. Dennis, is it possible for you to put on your camera?
Hello, can you hear me?
If it's
Yes,
possible,
we
stop
can.
sharing. If you can hear us, stop sharing, go turn on your video, and then you can come back and continue your presentation.
Okay, okay.
All right. So while we're
Yes. Is it okay
for
now?
Mr. Daniel to do that, please, the next group should get ready very long for your presentation. So we can't still see you.
Is it good now?
Just go ahead, please. Go ahead.
Okay. Talking about the introduction of
All right,
ADR.
your screen is still dark, but please, for the want of time, just please go on with the presentation.
Okay. For the introduction of for ADR, it has been noted that the dispute is inevitable in the world. Dispute is inevitable among men, is inevitable among the society, among women in the society, is inevitable among the people in the community, and it is the role of the society is to maintain is to ensure the maintenance of peace, law, and order. And in order to bring commitment to the society, it is raised that one of the informal ways to bring a settlement of disputes is alternative dispute resolution. Without wasting most of our time, dispute resolution borders on different ways. It talks about different methods, different ways people can come together to resolve to resolve their disagreements, to resolve a dispute which occurs among themselves or among group of people without going into litigation, without going into trial, without going to court, in essence. So now, talking about the history of alternative of dispute, alternative dispute resolution. It has been noted that movements has been negotiating and settling disputes formally and informally before the evolutions, before historical journals has been recorded, and the formalization of ADR was brought by an American litigation lawyer called Eric Green. Eric Green was instructed on a last case of commercial disputes involving the alleged infringement of certain patent devices. When this happens, he make use of legal proceedings comment on that commercial dispute resolution, and he saw that the parties involved, have spent a lot of money. He saw that the legal proceedings is taking half a year for the preparation of the case hearing, and is looking out for an alternative that will be more faster and that will be more safer in resolving these people disputes. That is why he talked with them, the parties, and the parties agreed to run a mini trial. The parties agreed to run a mini trial, and it is chaired by a neutral judge, a neutral third party who was a former judge. So as a result of that, certain rules was agreed during the proceedings among the parties. And
Sorry, please. I want to confirm if it's only me that's having issue here, Mr. Daniel.
Yes, it's not very
We
audible.
can hear him.
He is not very audible. He should try to increase his volume. I thought maybe it's only on my side.
okay. Can you
And the font size of your projection, if you can increase it, you'll be good. They are not very visible.
Please, Mr. Daniel, if it's possible.
okay? Can you hear me now?
Yes, we can hear you now.
Okay. So as I was saying, can you see this? Okay, as I was saying, as a result of this, some rules were accepted, some rules were agreed upon by the parties, and this result to this approach was called this alternative dispute resolution. So now moving straight to the definition of this alternative dispute resolution. ADR can be defined as the collection of procedures can be defined as the collection of procedures used for the purpose of resolving disputes out of court. As I've mentioned earlier, it is an alternative of resolving disputes without going to court. So now the legal framework of ADR in Nigeria can be traced back to Section 19 of Section 19 sub D of the 1999 Constitution of Federal Republic of Nigeria as amended, which provides for the disputes by arbitration, mediation, conciliation, negotiation, and adjudication. Also, Order 19 of the Federal High Court Rules of Nigeria provides supportive court intervention in arbitral proceedings. Order 28 of the High Court of FCT and Lagos State Civil Procedure Rules also provides of case. Rule 15 sub 3D of the Rules of Professional Conduct for legal practitioner mandates lawyers to attempt an alternative dispute resolution before bringing any matter before the court of hearing. So all these are legal framework of Nigeria, legal framework of ADR in Nigeria. Also, the processes are meant to be confidential, less formal and stressful. We have methods of ADR, and among the methods are negotiation and mediation, which I will be focusing on in the presentation. So moving straight to negotiation. What is negotiation? Negotiation may be defined as any form of direct or indirect communications through which parties who have conflicting interests discuss any form of any action which might take together to and ultimately resolve the dispute between them. What are we saying in essence? We are saying that negotiation is a process in which people
Mr.
use
Daniel, we
forces.
are not hearing.
Hello, can you hear me now?
Yes, we can hear you now.
Okay. What we are saying in essence is that negotiation is the process whereby people made often to settle disputes, whereby they negotiate all types of disagreements in our lives and in their workplace. What we are saying is that when negotiations are used in legal aid among disputes, which otherwise would be litigated as settled before the trial, because disputant talks about issues and discusses ways of to resolve their differences. Negotiation may be used to resolve an existing problem or lay down the groundwork for a future relationship between two or more parties. So now, whenever they are talking about negotiation has a different kind of it works best when disputants are willing and able to talk about their dispute and to compromise their differences. It is unlike arbitration and mediation, whereby the outcome of negotiation is reached by parties together without resolving to a neutral third party. In essence, negotiation does not need a third party before negotiation can occur. Negotiation only can Negotiation is flexible. The process of negotiation is flexible and it is informal in order to ensure the confidentiality of the choice of the parties. Now, examples of negotiation, we have closing a sale, by asking for a promotion or salary increase in a workplace where you need a promotion or a salary increase. We go into a negotiation with the employer in terms of a common goal, requesting budget allocation for a project, also closing a sale, and also negotiation may take place directly between disputants who consult with their attorney as discussion proceed, or the parties may negotiate indirectly through attorney or other representative. Without wasting our time, I will be talking on mediation.
Mr.
Hello.
Daniel, we can't really hear you. Please, your audio is pretty bad. Please, can you kindly maybe move from where you are to somewhere that may be more, where you may be more audible?
Okay. Can you hear me now?
Yes, we can hear you better now. Please go ahead with the presentation and please try and
Okay.
wrap up.
Okay. Now talking about mediation. Mediation now is when parties who cannot negotiate together effectively may bring mediation to facilitate the negotiation process. When we're talking about negotiation, we said earlier that negotiation does not need a neutral person, it does not need a third party. But now, when it comes that the when it seems that the disagreement or the dispute is not as planned, mediation can come in, whereby parties who cannot negotiate together effectively may bring an intermediary or may bring a mediator to facilitate the negotiation process. It is defined as the intervention in a standard negotiation or conflict of an acceptable third party who has limited or no authoritative decision making power, but assists the involved parties in voluntarily reaching a mutual acceptable settlement of their disputes. We have made essence that mediation talks about the intervention of a standard negotiation whereby a third party comes in and the third party voluntarily assists the parties in reaching a mutual acceptable settlement for their of issues in their disputes. Now, in essence, it is an efficient and effective process that aims to identify mutual acceptable solution for both parties. When it comes about mediation is cost-effective process. It helps to identify what are the problems. It helps to identify what are the issues within these parties, and to provide acceptable solutions for both parties. A mediator is to guide the process. The third party now that comes into the scenario now is known as a mediator. Now, the mediator is just to guide the process as well, to help the parties to identify and concentrate on their major interests. The mediator the mediator must be neutral and should ensure that the needs of both parties are met. Yes, when a mediator is being chosen and when a mediator comes into the scenario now, the mediator must be neutral. The mediator must not support one side over another side. He must just be a neutral person and must ensure that the needs of the parties must be attended to, not that he will leave one side and he will not resolve the other side. And it is important to note that in mediator can enter disputes at the request of the parties, or being appropriate at be appointed at by an authoritative third party. It is also important that there's a key mediation activity is to identify the problem, is to identify the conflict, and to build a resolving solution for the conflict. Now, the examples of mediation. Examples of mediation. We have workplace conflicts, we have family disputes, we have business partnership disputes, we have community disputes, we have commercial contract disputes, we have divorce disputes. Whenever there's a divorce between the husband and the wife, you can call in a mediator who can settle the disagreement between them. Also, it works in a family dispute whereby the members of the family has issue over an issue, probably a land or something. You can invite a mediator to come in to discuss to provide a solution. Now, similarities between mediation and negotiation. Now, the first one, okay, these are the differences. In mediation, in it is made in mediation that a mediator facilitates the process, but in negotiation, the parties negotiate directly. They don't bring out in negotiation, they don't bring a third party. They don't bring a third party to the discussion. Also, the control of the process. In mediation, the mediator control the process, but the party control the outcome. The mediator control the process, the orders of how everything is being arranged, from pointing out the issue to providing a solution for them, but the parties only control the outcome of the discussion. In negotiation, the parties control both the process and the outcome. In negotiation, where there is no mediator, the parties have to control their process, both the process and the outcome of their discussion. The similarities between mediation and negotiation is both methods are valuable tools for resolving conflicts, more quicker and cost effective than litigation. We all know that litigation is time consuming, litigation is more expensive, and when you are bringing when you are resolving into ADR, when you are resolving into mediation and negotiation, it resolve the conflict very quicker and cost effectively. Also, both involve parties coming together to resolve a dispute or reach an agreement. In litigation, we know that it will actually favor one side over another. When there's a disagreement and you must go to court to resolve
Presentation.
judgment in your favor, it will actually. But in ADR, in mediation and negotiation, the parties will come together and reach a common agreement and reach to resolve a dispute and reach a agreement. The last thing before conclusion is the merit of ADR. The merit of ADR is flexibility and simplicity, as you said earlier. It is very flexible. The parties determine the process. The parties determine what we are going to resolve to. It is faster, that is quick decision making, it's reduced cost, it is less expensive, and it's a higher outcome satisfaction. It's both parties will be satisfied because this is what they agreed on. This is what the solution they agreed on. This the merits of ADR, inability to decide on criminal cases. Yes, one of the disadvantage of ADR is that you cannot bring criminal matters to ADR. You cannot bring criminal matters cannot be instituted in ADR. Also, cost limitation. We have time constraint and lack of enforcement. So, in conclusion, it is said that the law is dynamic. As the laws, as the community involved, as the society involved, there's always need for law to catch up with pace, and ADR is seen as the solution. ADR is seen as a way of improving access to justice for members of the public. Not everybody can afford litigation. Not everybody is interested in litigation. ADR has come in to bring a solution for that. Thank you, and that will be all for this presentation.
All right, thank you so much, Daniel. We had a little difficulty hearing you while you were presenting, but all the same, well done to you and to your group members for putting the second group come make their presentation. Group two, please, as soon as possible, so that we can get on with the rest of class. We don't want to waste much time on presentations alone. So please, group two, try and share your slides and start your presentation right about now. Do we have any group two member with us? Ready to step into make presentation on behalf of the group? Please go ahead and share your screen and start your presentation. Please, let's not waste time. Let's not waste time. Do we have anybody from group two making presentation on behalf of the group? Um, we don't have anybody from group two. Okay. All right. Since we don't currently have anybody from group two, and I don't know why you are unable to come up with your presentation. Same. We will not stop here. We'll we just want to dive into the topic for today from our moment. Seeing that we don't have any presenter for group two, that's please,
Hello.
yes. Hello, please. Who is speaking?
Okay, so I think you should put off your video so that you can have a better.
Good evening, everyone.
Good evening.
I'm trying to. I'm sorry. I'll be presenting on behalf of Group 2 and
Sorry about that. So please, sir, I was saying on this presentation, we would like to hear from our mentors on the discourse for today. Mr. Nashams, I want to hand over to you. Okay, Leslie.
Okay. We have someone from group. We have someone from group 2 that wants to present. So please give her the opportunity to do that quickly.
All right. Please, kindly do that as soon as possible so that we can have our mentors come talk to us today. So please, the group presenter for group 2, please go ahead and start the presentation.
Sorry, I'm Leslie. I'm a member of Group 2, but it seems that our presenters are having network issues. So,
So can you present?
I don't know if Abigail wanted to present. It seems she's also having network issues. I could just go ahead and share our slides. And
Okay, go ahead, please.
okay, let me do that.
Um,
Sorry, please give me a
Abigail.
minute. I'm finding it a bit difficult to do so.
All right, please
Sorry.
go ahead and start.
Oh, should we go ahead with the presentation without sharing the slides?
And I will help you share your slides.
Oh, okay, all right, that's good.
Please, you can start the presentation.
All right, so we are to
Hear me?
discuss. Okay. So we are to do an overview of ADR while focusing on arbitration and conciliation. So we'll start by defining ADR, that is alternative dispute resolution, and that refers to the processes and the different techniques used to resolve disputes and without resorting to the traditional litigation through the court system. And the purpose of ADR is to reduce the load that is imposed on the courts by reducing litigation cost and also reduce the time spent in litigation. Is also to promote collaborative problem solving and to preserve the parties' relationship rather than to make them enemies, because there's a saying that you can't go to court and return friends. So ADR tries to maintain and preserve relationship between parties without making them enemies when the court decides probably in favor of one over the other. ADR also provides flexibility and confidentiality and offers the party more control over the outcome of the ADR process. So the growing importance and application in modern legal context is that, as I said earlier, the courts are not overburdened. So ADR helps to alleviate caseloads and delays. ADR also facilitates international dispute resolution and addresses difficult and technical and multi-party disputes. ADR is also very useful in commercial disputes. It is able to resolve business conflicts efficiently. ADR provides accessible redress mechanisms. It also facilitates collaborative solutions and it is adaptable to digital transaction and conflict. So the modern legal context increasingly recognizes ADR's value and incorporates it into court-connected ADR programs. We have multiple shows, for example, on YouTube. You see There is one by Judge Femi Asaolu on YouTube. It is also kind of like an ADR program, and that is able to resolve some conflicts very well. We have contractual dispute resolution clauses. So in commercial contracts, parties are able to preempt that the disputes will arise, and they put in there that if these disputes do arise, that before resorting to court, they should be able to adapt one of the ADR mechanisms to resolve these commercial disputes. There are industry-specific ADR schemes, such as in construction or sports, by applying arbitration. Also in international trade agreements, for example, trade agreements between countries, they're able to resolve it through one of the many ADR techniques and mechanisms. And there are online platform and digital marketplaces. So the main method of ADR, we have mediation, arbitration, conciliation, negotiation, just to name a few. But since we are focusing on conciliation and arbitration, we would just focus on defining that. Let's start with arbitration. Arbitration is an adjudication process for the resolution of disputes, which is outside the courts. And the process is that a neutral third party, who is also an independent party aside from the disputing party, is empowered to decide upon the disputed issues, and after hearing the arguments from the parties. So the parties will state their cases. Is kind of similar to the court system, but not as formal and as rigid as the court system is. So the parties will state their dispute. They will each present their own cases and may also submit evidence in favor of their arguments, and then the neutral third party will decide. So for there to be an arbitration, some things must there are some requirements. First, there must be a dispute, since arbitration is an alternative dispute resolution, is to resolve a dispute. There must be the existence of a dispute. There is also to be an agreement to refer to the an agreement to refer the dispute to an arbitration when the dispute arises, and the agreement to be bound by the award. So the parties who resort to the ADR method, arbitration, would probably have had an agreement between themselves, perhaps in form of a contract, stating that if a dispute does arise in the course of their relationship, they will resort to arbitration to resolve the disputes, and they will also give a consensus that they will be legally bound by the final decision of the arbitrator, and the decision of the arbitrator will be enforceable on the parties, and then there will be an initiation of the arbitration. So as I said earlier, the arbitrator is a neutral third party. He does not take sides with any of the parties. He is a master of his own procedure, and he must act in accordance with the rules of natural justice. And his final decision, which is referred to as an award during the arbitration process, is binding upon the parties. Now, one of the rules, the arbitral rules, according to Article 3 of the arbitration rules, is that a demand that the dispute be referred to as arbitration, the names and addresses of the parties, a reference to the arbitration clause, a reference to the contract, which is what will lead the disputing parties to initiate the arbitration proceedings, and the nature of the claim, the relief or remedy sought, a proposal has to be as to the number of the arbitrators. The arbitrator may not only be a person, it may also be a panel, and it is the disputing parties that will decide on who will make up this panel and how many arbitrators should be on the panel. There will also be, where they opt to have just a single arbitrator, they will propose for the appointment of a sole arbitrator, and there are other things included in Article 3 of the arbitration rules. So I'll move on next to the second ADR method that we'll be discussing, which is conciliation. Conciliation is also an alternative dispute resolution technique. It is a method of settling disputes by consensus rather than by adjudication. So it is a bit different from arbitration, whereby the party is also up to have a neutral third party, who is the conciliator in this case, to also, help them. But a conciliator is different from an arbitrator in that he does not exactly make a decision which is to be imposed on the parties. Rather, he helps to facilitate communication between the parties and to basically help them to talk out the issues and for them to come to a consensual decision by themselves. So the conciliator does not make or impose a decision on the disputing parties, but helps them to facilitate the dispute resolution process so that they can resolve their issues amicably. So we'll be comparing this arbitration and conciliation with traditional litigation. One key difference is the flexibility that arbitration and conciliation offers. Um, with litigation, there are lots of formalities that should be followed, and whereas in ADR processes, the parties are a bit more flexible in deciding how things should be done. And they don't have to go through all the formalities that are involved with litigation, basically. ADR also saves time and costs as compared to litigation, which would take sometimes months, sometimes years before a case is finally decided upon. ADR, one of the main aims of ADR is to reach a solution in a shorter time. So ADR helps to preserve the parties' time and is also significantly less costly than traditional litigation. And another thing with ADR is the confidentiality advantage that it offers. In court, if you go to a courtroom, you see that different parties to different cases are seated, so everybody knows your business, right? But confidentiality is assured within the ADR processes in arbitration and conciliation. So um, as I stated the comparison with traditional litigation, I believe I've also touched on some of the advantages, but I'll also just breeze over that. The first one advantage is that it preserves relationship. It is also speedy and efficient, meaning that ADR is much quicker than litigation. You get to cut down the time that you would have spent in court, and it is also more efficient. As I said earlier, we also have the cost advantage. It is not as expensive as the traditional litigation is. However, there are certain limitations and challenges that ADR faces. One thing is the enforceability of decisions. In conciliation, although the parties are to sit down and talk out their issues and then to come to a decision where they will, before the conciliator agree to um, enforce, the enforceability of this decision cannot be really executed. Whereas in court, you have where a judgment is given. If a party or the parties fail to act upon that judgment, the court can enforce it through their court bailiffs, the sheriffs, or even the police, and the parties may even be sued for contempt of court, right? But in ADR, no such exists. There is also a lack of precedence. In courts, you have to, your case is basically built on what happened in the past. What did the Supreme Court say in a similar past case, and apply it to the current case? But ADR is not like that. There is no exact way of going to a certain case book and saying, what did this happen in this former ADR proceedings? None of that exists with ADR. There is also the perception of bias and a power imbalance. There's also limited appeal and dependence on party cooperation. Also, in courts, it is quite compulsory that the parties appear in court. However, if the parties do not come for the ADR proceedings, it is almost impossible for an ADR arbitrator or conciliator to proceed with the ADR proceedings. ADR is specifically now conciliation and arbitration, it is applied to certain things, like we said earlier, to international trade. And ADR has become an important and effective method for resolving cross-border disputes and international conflicts, and also international commercial transaction. It helps to resolve these disputes by avoiding complications arising from the differences in legal systems and judicial rights between the countries involved. So there are different benefits of ADR in international conflicts and cross-border disputes, such as the efficiency we find in it, the cost effectiveness, flexibility, the preservation of relationships, and also the confidentiality. We have certain regulatory and institutional frameworks, and such as the UNCITRAL model law on international commercial arbitration. We also have the ACA, which was recently that is the Arbitration and Conciliation Act. The recent reform was done in 2023, and this governs arbitration and conciliation in Nigeria. We have the Convention on the Settlement of Investment Disputes between states and nationals of other states. That is the ICSID Convention. We also have some key organizations and institutions which support ADR. We have both home and abroad. We have the International Center for Arbitration and Mediation in Nigeria, the Chartered Institute of Arbitrators. We have a Nigerian branch. We have the Nigerian Institute of Chartered Arbitrators. We have the Institute of Chartered Mediators and Conciliators. We have the Lagos Multi-Door Courthouse, the Nigerian Bar Association, and the Lagos Court of Arbitration, just to name a few. The standards and best practices for ADR procedures include adherence to international standards, training and professional standards, confidentiality, the fact that these ADR methods are voluntary, in that the parties voluntarily offer themselves to these procedures, not that they are served with a notice of courts that they must appear. There's also the neutrality of either the arbitrator or the conciliator. There is efficiency in ADR proceedings, the flexibilities. So those are the standards and best practices for ADR procedures. So the um, mm, So the innovations in ADR in Nigeria include the Arbitration and Mediation Act, which was reformed recently in 2023, replacing the 2004 Act. The new law introduced several key changes, which include electronic arbitration agreements. We have interim measures, award review tribunals, reduced default arbitrators, limitation of time, third-party funding, and online dispute resolution. So you can see that a lot more law reforms are making it easier for people in Nigeria or to be able to engage themselves in ADR proceedings. In Nigeria, we have potential future developments and impacts of technological advancements on ADR, which include AI-powered dispute and blockchain technology resolution tools. We also have the increased adoption of online dispute resolution, that's the ODR platforms. We have virtual reality in ADR training and mobile-based dispute resolution applications. So a lot of things are being done to make ADR techniques and methods easier and accessible to all. And these technological advancements will increase access to ADR services, reduce the cost and delays associated with traditional dispute resolution methods. It will also enhance the efficiency and effectiveness of these ADR processes and improve the skills and knowledge of ADR practitioners through technology-enabled training. There are also common scenarios and contexts of ADR in commercial disputes. We have seen ADR work in not just commercial disputes, but also in family disputes and labor disputes. So these are the major scenarios in which ADR is effective in. So to state lastly, examples of where ADR will be an appropriate option in family disputes are, for example, in child law, in situations involving custody of the child maintenance. These are often as a result of perhaps divorcing couples, and obviously a issue led to them divorcing. So ADR will be effective on bringing focus on the importance of the care of the child and to help the divorcing parties to realize this. We also have divorce and financial settlements. ADR is also going to be really effective in this. We also have family property disputes. We have conflicts like inheritance between siblings, alienation and succession disputes, which may arise due to inequality in distribution of assets. ADR, for example, through mediation, is a great way to address the conflict by identifying the interests and the goals of the family members to facilitate negotiations and to reconcile their differences. ADR in labor disputes also is able to resolve conflicts between employers and employees, or employers and employees over wages, and also resolve or make there to be an argument to make better working conditions. So that is all on our slides. Thank you for listening.
All right, thank you very much. Thank you very much, Leslie, for helping us with the presentation for your group. Um,
All
all
right.
right, sorry about that. Thank you so much, Leslie, again.
Um, well, I must comment the. And then, if can you hear me?
Yes, I can hear you, sir.
Okay, the mentees, can you hear me? Can the mentees hear me?
Yes, sir.
I hear you, sir.
Okay. So
Yes, sir.
let me start by appreciating the mentees for putting this together. The essence of the general overview, just as the name implies, is to have a general knowledge. Okay, so I can see that. Okay. So the essence of having the general overview is for the mentees to be able to have an idea or knowledge about what ADR is all about. That's why it is ADR. It's not particularly mediation or arbitration or negotiation, but you should have a general overview. And I must appreciate the mentees for putting these things together. You know, based on their own knowledge or capacity, they have been able to do well. So I will commend you for that. So having said so, if you have some question in respect of what you have had thus far, you can put it on the chat. You know, we're going to look at it. Let me go to the mentors. Can I don't know, Eunice, please, if any of the mentors around, you can put on your video so that I'll get to know those who are in the house. Eunice, Miss Pa. Okay. All right. Eunice, are you with us?
Hello, Nanchang, I'm here. Tohib is here.
All right, thank you. Okay, oh, thank you very much. Oh, this is interesting. So I must say that you are actually lucky and privileged to have all these sets of mentee turn out to be able to give you some perspective in some of the areas that possibly you must have left out, and then to answer your questions. We have the mentees all around, people who have practiced very vast um, in ADR. Mr. Amuda is very vast in arbitration and other ADR mechanisms. And I can see Eunice. Thank you for joining us. Eunice is also another ADR expert, all the way from. You didn't. I think they have read their profile. Dennis has read their profile. Mispa is all the way. She's a Cameroonian, and she is presently in Mispa. Are you in Kenya or Uganda present?
Kigali.
Kigali. Oh, that's good. Okay, so thank you. So you have all these experts in the house to be able to attend to you. So let me start with Mispa. Mispa, were you with us from the inception? You had the presentation of the mentees?
Yeah.
Okay. So we are looking at the overview of ADR. Will you want to maybe give them a perspective or add one or two things from what they have discussed, or some of the things they have left out from the conversation?
Yeah, Nachan, thank you very much. Good evening to all my other colleague mentors in the house, and to the mentees, and to my mentees from Kigali, Rwanda, the different university students here represented. You are all welcome. I hope you are learning from what the settlement house mentees are doing. So it's an opportunity for you all to learn also as the YMG of the Chartered Institute of Arbitrators. So honestly, I must commend the presentation by both Group 1 and Group 2. Haven't gone through their slides as well. I thought the settlement house assisted them in arriving at this outcome, but if they did this themselves, then I must give them kudos. And these are some of the opportunities that during our time we did not have. But today you people have it, so please make maximum use of it. I used to say there are two types of, or two forms of mentorship. There's mentorship that you are being mentored as a mentee to know. And then there is mentorship also in this our space where you are being mentored as a job. So this stage where you are being mentored to know about the industry and how the industry operates. Some of us, we still take mentorships on different platforms, but those ones are job opportunities. Like when I say job, means arbitration or ADR jobs. So you can either be mentored and appointed as a registrar, mentored and appointed as an arbitrator, and so on and so forth. But nevertheless, I will say that you cannot exhaust it all because it's an overview, but I would like more to comment on more practical things about the overview of ADR and some of the current issues that are upcoming with the different laws today in the industry. For example, I heard you people mention, I didn't hear you mention AMA, that is the Arbitration and Mediation Act 2023 of Nigeria.
Yes. Yes.
So AMA is the recent act that carries issues of arbitration and mediation from its processes to the end outcome. So I advise you people to look at it, master it. Some of us young arbitrators in the industry as well, we wrote something, an article that will soon be out. What I would have known You know, some of the things I would have known is laying my hands on the instruments. Let me tell you, whether domestic practice or international practice, they are all founded on those instruments. The model law, which most countries have domesticated, that's under arbitration. That is the UNCITRAL model law that most countries have domesticated. Like, for example, Nigeria has domesticated to the AMA today. You have Rwanda. Rwanda has the Conciliation and Arbitration and Conciliation Act 2008. And you can name it and name it. So many countries have domesticated. And then there is also the UNCITRAL rules that so many other countries have also used it as a model rule. They have adopted and adapted to their own institutional rules, or some ad hoc arbitration. Ad hoc means a sole arbitrator, whether institutional or private. When there is one arbitrator, is called an ad hoc arbitration. They can now use the UNCITRAL rules. In practice, whether the parties mention it in the arbitration clause or the arbitration agreements, the arbitrator can bring the rules that suits the process, okay? Whether it is the UNCITRAL arbitration rules, whether it is the Kigali International Arbitration Rules of 2012, or is the UNCITRAL, yes, UNCITRAL, the amended UNCITRAL is 2006, and then, or it is the ICC rules of 2023. So whatever those international rules, or it is the Chartered Institute of Arbitrators rules and guidelines, it depends on which one is being used. So you said something about, that's presenter 2. I heard you said something about treaties. I want to make this clear under investment treaties that states, especially for state investment, states sometimes might not have an arbitration clause. But when they are signatories or parties to an international investment treaty that has an arbitration clause, they are bound to it automatically. These are some things that lawyers or practitioners face in the practice currently. And they'll be like, oh, there's no arbitration clause, there's no clause, there's no clause. But they forget that those states are bound by the supreme clause or supreme treaty clause that is found in the convention or the treaty that they have signed or ratified. Okay. Then one thing I also want to make mention of again is that formerly mediation was mostly used in construction disputes through the process of adjudication. But today, mediation has become a very common practice. It's going, presently as we speak, there is even the traces of mediation in criminal litigations, okay? So mediation is gradually taking the speed of light in some form of dispute resolutions than arbitration itself. Because, like, for example, Rwanda has something they call restitutive judgment or restitution. For example, say in an insurance dispute where somebody died, that's a typical litigation. It's a typical litigation. But now, if the insurer and the insuree, that's the insurer, the insurance company, and the insuree, the beneficiary, who has to benefit from a premium from that insurance contract, if there is one in existence, they can decide to go to mediation. You cannot actually pay the life of a human being, no matter the amount of money, or no amount of prison term or life imprisonment will bring back your disease. You see? So those are instances today. Currently, we are working on a product in that aspect with some other consultants on consultancy. I drafted something on that. So this is actually to decongest the case log of the courts, which so many courts today are getting abreast and understanding the procedure. If you see today, so many judges are going for trainings in mediation and arbitration. Nigeria is one of those countries that they practice a lot of court annex mediation, and so many other countries are copying from that practice, actually to do what? To reduce the case log of the judges. And their dockets are getting bigger and bigger every day. And you know, there is no development where there is no sweet processes of resolving dispute, because dispute obviously is inevitable in transactions. Okay, so I will not be repeating what you've said. That's why I'm trying to make it a more practical understanding, because when we are mentoring you to go out there as professionals, because you need to understand these technicalities and not, it's good. I consider you already know the theories because you have presented it to us. So that's why I'm bringing you some of these technicalities in whether in arbitration or in mediation. You guys also did a very good presentation about negotiation. Negotiation is a two-man's business. You can see a typical example of a negotiated case that, like the Bakassi Peninsula case, that was a very good case of negotiation where Nigeria and Cameroon, they sat on the negotiation table. They discussed as a two-man. The UN and all the other international organizations that were there, they were just observers to make sure that the outcome of the negotiated agreement becomes binding. So that's just to tell you how these processes are. It is when negotiation fails sometimes that we can move to mediation. And sometimes a negotiated outcome or agreement can be used as a ground to set for mediation or arbitration. So, dear mentees, thank you for your presentation. I hope this should be the third series of this mentorship program that I'm participating as a mentor. Let me allow my other co-mentors give their own views and contributions. Thank you very much, Settlement House.
All right, thank you, Ms. Fa, for your contribution. We may come to you because the mentees may have one or two questions. I've actually noted some things down in the course of the presentations, which I believe that some of us will be available to address them. So we have over 40-something mentees on the call. So I believe that if they have questions, they can drop it on the chat. Dennis will be taking note of them, and then we will be giving some answers to them. So let me come to you, Eunice. They said ladies first. I don't know whether it is ladies first after men or before men, but I've decided to go with before men. So, Eunice, you have listened to the presentation of the mentees. We just want to give them a general overview. That is why we did not opt for a situation where the mentors will just make a presentation. Now they have listened to their commentees make presentation out of the research they have made, and it seems they have a rich presentation. And then we are here to be able to give them a perspective. So we are to look out for maybe some of the areas that some of the things they have mentioned that are either right or not, maybe they are not correct, or they need some panel beating, or, that's the essence of the mentors being here. And then we have over 4 or 5 of the mentors in the call. So you have listened to them. Is there a particular area where you feel you want to lend your voice in some maybe 3, 4, 5 minutes so that the mentees will, I hope the mentees are taking notes. Even me, I'm actually taking notes as well. There are some things that will be mentioned that you may not find it in a particular book. So Eunice.
All right, thank you so much, Nakchang. And then the Settlement House, JIIPCC, thank you for inviting me. This is a rare opportunity, and I do not take it for granted. Thank you so much. And I want to say thank you to all the mentors that are here. Mispa, I've listened to you and I've learned so much from you as well. Abib, did I get the name right? Mr. Amuda, like Nachand have been saying, thank you for being here, and every other person. And to all the mentees, I want to say well done, because it is not every young person that is open to learning and being taught like you have created time to be here today. It's commendable. And to your presentation, it was well researched. I think you did so well with the research, yes. Particularly the second presenter, it was very, very deep. Well done, everyone. Well, not just to, I don't want to repeat everything that you have said. I think you've covered the field, and Ms. Pat actually even shed more light on some of the points, or many of the points rather. What I just noted down for the first presenter, talking about ADR not being applicable in criminal matters. I think Ms. Pat has mentioned that in some criminal matters, especially minor offenses now, we now use restorative justice, which is applicable particularly in Lagos. I don't know of any other states, but in Lagos, in other jurisdictions like Canada, even in the UK, there is now something like restorative justice, which is a kind of alternative dispute resolution as well, where an offender had admitted guilt. So instead of sending them to the prison, they make them to realize what they have done, the effect of what they have done on the victims, and then maybe subject them to lower sentence instead of sending them to the prison. So ADR is also applicable in some criminal matters. Also, you mentioned, that's Samuel, that lack of enforcement has one of the demerits of ADR. I think that is, you can enforce if there is an agreement through ADR, it is enforceable, just like the court judgment. In fact, it's even a shortcut to getting a judgment, because when you go to court, you go to the trials, you have judgment. When you have judgment, especially in monetary claim, it doesn't translate into money or enforcement. You still have to go through the enforcement procedure. So it is when you have an agreement, you can initiate the same process to enforce that agreement through mediation, especially with court next mediation. You can easily go to court by originating summon or motion. So you don't go through the trial because it's a consent judgment, an admission. So it is enforceable, okay? Then you mentioned, okay, using ADR for divorce. I would rather you use for family disputes like the second presenter did, because in Nigeria, as of today, and in so many other jurisdictions, it is only the court that can dissolve a statutory marriage. The court has to pronounce a statutory marriage dissolved. But other matter related to family matter, maybe like settlement of property, like custodies, can be resolved through mediation. In fact, the Matrimonial Causes Act provided for compulsory conference, which is a form of mediation or ADR. But for the decree of the solution itself, is the court that can actually make that pronouncement. Okay, to the second presenter, I think I don't even have much to say, because I noted down when you were in one of your slides, you noted Arbitration and Conciliation Act 2023, and I noted it down that no, it used to be Arbitration and Conciliation Act, and it has now changed to Arbitration and Mediation Act. And in later slide, I think you mentioned that perhaps maybe it was just too much reading. It may be confusing sometimes, but I thought that you did that. Yeah, I think Ms. Pat mentioned where agreement do not cover maybe the seat of arbitration, the number of arbitration. I won't be going into that because I'm not an arbitrator. Yes, I did a course in arbitration, but no, I'm more of a mediator and a conciliator. Yeah, then maybe I should just point out on a difference between conciliation and mediation arbitration, like you have mentioned. There is not much difference in the practice of mediation and conciliation. In fact, it's the same skill that you use. It's just that conciliation, most of the time, is a statutory provision. In the UK, the employment law prescribe that before an employee can approach the employment tribunal, they have to go through conciliation through a body called ACAS. That's Advisory Conciliation and Arbitration Services body. It's a government body. So you have to go through conciliation, and it's the same process. It's just that unlike mediation that we do, or that we are familiar with, whereby you sit both parties and then you mediate between them, you don't meet the both parties. You call them, you call the claimant first. If the claimant give you consent to talk to the respondent, then you talk to the respondent, and you go as in between while you still use the same skill, the same method that you use in mediation. So even the same thing in Nigeria, and Labor Act also provide for conciliation. So that's just the basic, I think it's just the provision, the enabling laws that make it so. So there's not much different. It's just a matter of name. As far as I'm concerned, having practiced as a mediator, as a conciliator. Thank you. I think that's what I've noted down here for now. If you have any question, thank you. I will be welcome. I will be so happy to answer that. Thank you very much.
Thank you. Thank you very much, Eunice, for that wonderful contribution. And that is why we decided to take this kind of shape for the mentorship. We want a situation where the mentees will do the work, and then they will have the ability to ask questions, have deeper understanding when mentors are speaking, and then mentors will be able to pick up some areas where they've missed out or have a misconception and get it corrected. I will beg the mentees, some of the knowledge that these people are sharing, the mentors are sharing, are not knowledge that you are going to go and get in a book. And then if you are going to go and read a book, you are going to read a lot of books before you will get to know some of the things that they are just sharing with you this easily. So by the time you take some notes, in the course of time, when you start taking some trainings, you see that some of the concepts you are already conversant with them, and then you just make it concrete. When you go into a mediation or arbitration training as a novice without knowing anything at all, it used to be very, very uneasy, so to say. So please take notes and then jot down questions which we can answer now or in the subsequent meetings that we're going to have. So having said so, thank you very much, Eunice, for that wonderful presentation. Now, Mr. Amuda, I believe that we have listened to the presentation of the mentees. We are looking at a general overview, and then we want these mentees to have an understanding of, if possible, a highlight of most of the things that they should know or should be expecting in the coming weeks. You know, so you have listened to them. I don't know if you have jotted something or you take note of something that you want the mentees to take particular note or attention of.
Yes, thank you very much. Thank you very much, everyone, and thank you for having me. I commend the two groups for the wonderful presentation. I've had the opportunity of listening to both of them. I'll be brief because I also have some engagements just scheduled for later today, and I see that we've actually, we've taken a lot of time. Again, the teams have done justice to the discussion, and of course, the two speakers before me, mentors before me, have also given some insight that some of the things I wanted to note to the mentees. I commend you all. I also want to note the issue of the Arbitration and Conciliation Act, which is now the Arbitration and Mediation Act. Some of the things that was said, in the presentation, in theory, yes, they are right, in terms of, negotiation, mediation. But, looking at the practical aspect, you tend to see some, some mix in this, and that's why that's something I just want to talk about with the student, with the mentees in terms of the practical aspect of, this ADR processes. For instance, let's take negotiation, for example. You can have negotiation before a dispute and of course after a dispute as well. For instance, if you look at the case of Nigeria now, where Nigeria is now currently seeking to, in a way, negotiate out of a $70 million claim by Songshan, which is a Chinese investment company. That's a form of negotiation. Now we're trying to do a settlement or to discuss or to negotiate our way out of the arbitration award. So you see, it's a negotiation out after the dispute itself. So it's something we might have done earlier, but of course the tribunal in that case said we didn't do it. So we didn't have a sealed offer, a Canada Bank offer. We didn't offer them, maybe, the claim was over $1 billion then. We didn't offer them anything. Whether Ogun State breached the contract or not is a different issue. So that's negotiation after the the dispute has been concluded. Again, you have situations where where it's being said that negotiation is just by the parties alone. Sometimes negotiation is being the council assists the parties in negotiating. Now, whether you want to include council as part of the parties is also something else. Again, the council are not maybe third parties, but of course, council assist negotiation. I've had the opportunity of assisting my clients in a couple of negotiations. One involves an offtake agreement with an oil company. Where we were able to negotiate a settlement. Within the parties. Of course, you must have management confirmation. Some of the things that were not also mentioned was the fact that negotiations sometimes it can either work or not work, because, for instance, during the oil company negotiation we're trying to do, we had to get the authority of the management, and we were in a time zone that was over 6 hours ahead of where the management stays. So in any case, we have to wait for the management to the person with the actual authority to wake up before we can conclude on that deal. So those are some peculiarities that parties have to take note of. Mediation sometimes. Now we've talked about cost, right? Cost of ADR. You can either have it both ways. The general view is that ADR is much cheaper. ADR is much cheaper and is much cheaper. But what we're trying to see now, while it's good to actually adopt ADR, what we are seeing now is, in fact, now ADR is now getting very expensive, right? For instance, looking at the arbitration or the Nigeria example that I was talking about, the award is a public award, so this is not a confidential matter, right? The Nigerian arbitrator was paid over, I think, £140,000. If you calculate that, and then the two British arbitrators as well, in totality, the arbitration fees alone was going into over $500,000, £500,000. Right now, if you look at this, again, the litigation fee, the cost of counsel alone that the claimants claimed was over £3 million. Right, £3 million that the claimant counsel claimed, and then the cost of that the Nigerian counsel claimed was around £400,000. You understand? Now, compare this is an arbitration with litigation, and look at whether indeed, I've also done arbitration where the fee of the Nigerian counsel there was 300 million naira, right? Now compare this to actual figure of, litigation if you go to court. For instance, a customary court or a high court claim, you won't file anything more than 10,000 naira or something, or whether you file 50,000 naira and things like that. If you want to pay the counsel, it's still the counsel fee that is going to be much more expensive. Depends on the counsel that you engage. Of course, the time factor is there, whereby you can have a litigation that goes 10 years, 5 years, 15 years, and things like that. But of course, you want to look at both sides. So that's why in practice, you start to have this divergence of what is obtained in practice and what we have in theory, right? I'm giving you practical examples based on my practice as a lawyer, based on my practice having involved in arbitration and, of course, mediation for a couple of years, right? So that's what. But again, this doesn't mean that you will achieve results, your timely result, with whether mediation, whether with arbitration. Again, it also goes to mediation. I've been involved in mediation where the fees of the mediator was also going, this is in the UK when I was in England and was, practicing, the fees of the mediator was going to over £80,000, £100,000. Again, some mediators will charge at least £4,000 or £3,000 per hour, or per 8 hours or something, depends on how it's the type of mediator. So if you look at IPOS mediation, you want to engage a mediator, you have to pay and things like that. And then the mediator charge per, whether for 4 hours, whether for 6 hours, and then tells you this is also what you're going to pay for my extra time. Right, so these are the realities of things. You understand? So again, but you achieve results compared to, of course, traditional litigation, which now we're starting to see. Also, an improvement in the judicial system. Again, it's something that still needs to be worked on. But of course, you're going to achieve results with your mediation. Now, you now have to have a balance as to whether indeed there's that commercial interest of time. We want to get a result now as a business, which you have to do. Again, the longer you take a case, it affects your share stock, it affects your commercial public view and things like that. You understand? So there's need to be a balance between the interest of the company, whether we want to get our result now or whether we are willing to wait, in time. You understand? So those are some practical concepts, in that I just said. Let me just point out and things like that, to pass. So ADR is a fantastic process. It continues to grow. We continue to improve the system. There are a couple of things that still need to be improved, even with ADR, even in practice as you go. But I won't want to waste a lot of time, with this. We've had a lot of, we've taken a lot of time. So I think, but fantastic job to the two groups. And of course, I look forward to, engaging with you more in future, whether personally or, in events such as this. Thank you.
All right, thank you very much, Ms. Amuda, for that wonderful contribution. The mentorship is for about 5 weeks, and we're going to be meeting every Wednesday from now, next Wednesday. So the mentees, you know that you have resource that you can utilize. So please, you go make your research. If you have questions that difficulties or things you don't understand, these are some of the things that you should be bringing up for the mediators and the mentors to be able to help you address using their vast knowledge and experience. Thank you very much, Mr. Amuda. And in case if you want to take your leave, you can let us, maybe just let me know quickly.
Yeah, thank you.
Privately, and then
I
that
think
will be
probably I will do that because I've actually I have a meeting in India, and India is 4 hours 30 minutes ahead of us. So now they are informing me that it's almost 10 or something now over there, or 11. So I have to actually meet them. But I apologize and thank you very much,
no
everyone.
problem. Thank you. We're
Yes.
happy to have you, and we look forward to meeting you eventually next week.
Thank you very
Yes.
much. Thank you.
You can excuse yourself, Councilor Munda. You can excuse
Thank
yourself.
you. Thank you.
Hope
Thank
we
you.
meet again next session.
Thank you. Thank you.
All right.
Thank you. So
So
nice to
thank
meet
you
you.
very much.
Bye. Thank you.
Yes. So initially I saw Mr. Samuel. I don't know if he's still with us, Mr. Samuel. Oh, the ambassador is here. Okay. So I believe that you can hear me. So in the course of the discussion, the mentees have made their presentations, and then we just want to hear your wonderful ambassadorial voice to all that have transpired, so that the mentees will have this rich experience in this first session of an overview of ADR. So if there is any particular thing you want to draw their attention to it in just a few minutes, so that we'll see how we can entertain a few questions and then we call it a day.
Thank you so much, Prof. Natchank, for this opportunity. I respectfully greet all the mentors in the house. It's so good to see each and every one of us again. I am having a meeting by 8. So let me see what I can quickly chip in. All has been said. Let me approach my response from a different angle, taking into consideration that we've been able to touch on the presentation of the mentees. Let me appreciate Group 1 and Group 2 for a thorough and well precise presentation. Thank you to all of them. Let me look at it from a technical angle, if I may. I'm looking at the slide for Group 1. I'm looking at the slide for Group 2. I wouldn't know if the preparation of the slide was done by one person or it was shared to different persons. Let me comment on Group 1 presentation. Group 1 presentation, you maintain a uniform font almost throughout your presentation, but your slides, when you're preparing your slide, try and make it increase the font. You may need to have more slides, but making sure that the fonts are legible when making your presentation for persons, for your viewers to be able to read it clearly. Then for Group 2, Group 1, you can make your slide interactive, inserting pictures, whatever you think you can do to make it interactive and encourage people to stay on mute. Looking at the slide for Group 2, they did a lot of good packaging presentation, but we do not have uniform fonts and uniform font style in each of the slides. Uniformity is needed to make your work appealing. Now, continuation from where the last meeting just stopped, we have rephrased the expensive or cheap nature of ADR. I think we always say it is cost effective. In as much as you may end up spending so much in ADR, the cost effective nature of ADR comes on the fore when even if you spend so much and you achieve the result within a short period of time, it is still appreciated when you spend a little and it takes so long. I believe if we have clients and you let your client know, can you pay XYZ and we will see how we can resolve this matter in short time, or you pay so low and it takes so long for it to be resolved. So we are not looking at the quantity of the amount being expended in the process. We are looking at the duration of the dispute, how soon. So it is cost effective. So ADR is cost effective, not necessarily expensive or cheap, but cost effective. We appreciate the fact that a lot of research has been done in making this presentation, but as ADR expert, understand clearly, continue from what one of the mentors said. Being good in theory is different from being good in practical. So you may get a culture shock when you experience that on the field, speaking in practical terms, some of the things that are written in text may differ from what you encounter practically. There may be no meeting point. Now, what do we need to do? From your presentation, it is obvious that all of you worked together, especially group 2. I'm sure the assigned person for the presentation was not around. Somebody else took up the challenge to make presentation. It shows that we are collaborating. In the field of ADR, we need a lot of collaboration. Nobody knows it all. And even if one person knows it all, we cannot do so much as an individual. The future of ADR is bright, knowing fully well that people are beginning to come together to understand the need of uniformity and collaboration in expanding the frontiers of ADR. We have started well and we must maintain this momentum. When the list of institutes was being mentioned by group 2, I'm sure you mentioned all the other institutes that you know of, and the very institute that is playing host to this mentorship program. I didn't hear you mention Shati. Settlement House ADRC is also an ADR institute. So please, I think that should be included in the slide. What career opportunities do we have as ADR practitioners? You can be good in your presenting. You can be good in doing research. You can be good as a consultant. So welcome to a world of endless possibilities. It is not knowing so much that matters in ADR, but the ability to make a difference. We are not just going through all of this for head knowledge. ADR is a lifelong ministry that we have direct impact on your life as a person. So don't just see this mentorship program as making an attempt to impress the mentors, but you should also see yourself going through a paradigm shift in your culture, in your behavior, in your attitudinal disposition to others, making it felt practically as an individual. Where do we start from? You can begin from your Jerusalem. You can begin from where you are. What dream do you have? What vision do you have? Begin to make your plans to make a mark in this phase of ADR. A lot of things will confuse you, but the confusion should prepare you to learn more. So much reading needs to be done. So much dedication needs to be done. Beyond impressing the mentors, get set to make a mark and an indelible impact in the field of ADR. Thank you for your attention.
The ambassador himself. Thank you very much, sir, for that wonderful contribution. We are always happy to have you, and it's a delight. The mentees, I believe you have been taking note of all these important aspects. You know, he has raised the issue of career opportunities for some of you who may want to form a career out of ADR. Is actually vast, and there are many things. When I'm concluding, I will mention one or two things. We have some questions. I think all the mentees have spoken You know, we have some questions on the chat, and then Eunice, I don't know if you are around before you leave. Eunice, there's a question that is directed to you, or maybe you attempt that.
Okay.
So yes, we have a question that is directed to you. Thank you so much, Ma. Eunice, can you please briefly go over the slight difference between conciliation and mediation? So maybe in just few seconds, you can just help them understand what's the difference between mediation and conciliation. That's what they are trying to find out, and they direct it particularly to you.
Okay. All right. So the difference, like I mentioned when I was talking, that is the enabling law. If you go on the internet, they will tell you, oh, conciliator can make recommendation, why mediator cannot make recommendations. It all depends on the law that is enabling you. For instance, in Nigeria, the law prescribes that conciliator can actually make recommendation with the consent of the parties. The conciliator is appointed by the Minister of Labour after negotiation had failed. In the UK, I currently work as a conciliator with the body that deals with ACAS, but I'm not speaking as ACAS representative here, so that's a disclaimer. But from my experience, you don't advise, just like you don't in mediator, as a mediator, but you can give general overview of law, because some people don't have understanding of the law. So you can generally mention the provision of the law. This is what the law says. In the previous matter, this is how the court rules, but you cannot advise parties. You cannot compel parties to make a decision that this is the decision you should make. So, but you can refer them to some authorities, to some cases, or send them links so that they can read up and have understanding, which I believe as a mediator, especially if you're an evaluative mediator, you can also do that as well. However, here they would say to you that, oh, mediation is not binding, but that would be in the context of employment-related matter. In the context of employment-related matter, mediation is often used in a continuous relationship. Maybe let's say there is a breakdown of communication in a workplace, and you want the workers to be able to work together. You come together, you try to listen to them, you mediate between them and resolve it. So there is no intention to create legally binding agreements. And you know, the constituent of contracts, there must be an intention to create to enter into a legally binding agreement. If you are a student of law, you will know that. So when you're mediating within that in that context, there may not be need for me. There may not even be like I don't have intention of suing or going to court, but just to allow for a continuous, harmonious relationship. But when it comes to conciliation, there's already a potential claim that may go to the courts. And here you are calling a conciliator to come and say, okay, try to help us reconcile. So if there is an agreement coming out from that conciliation process, it is binding. And parties can take it to court and enforce it. Both in Nigeria and in the UK, parties can enforce it. So it all depends on the context under which you are really operating. So that's why I mentioned that there is no much difference. You use the same skill, the same procedure, telling parties that it's a voluntary process. You cannot compel parties. And you cannot say parties, you must make this decision, except they have allowed you or given you that permission to say it. That is in Nigerian context. But here in the UK, you cannot make recommendations. I don't know if that has answered your question.
Thank you very much, Ms. Eunice. There's another question for you. What is the determinant, or what's the parameters for determining matters that should go for restorative justice? You know, you mentioned that, so maybe you can just give
Okay, so for restorative justice to apply, the matter must have been filed in court. There must have been an admission of guilt. So it's not a way to avoid or to just allow criminals running about in the society. There must be admission of guilt that you are guilty. And it has to be a minor offense. For instance, in Lagos, sexual offenses don't go through restorative justice because they are serious offenses. But maybe like you kill my goats, you stole money, things like that. So once you have admitted guilt, so how do you want to
partner injury?
Yes. So you now like, okay, are you ready? Are you willing to meet with the victim of the offender? Then the facilitator will also ask the victim if they are willing to meet with your suspect, okay? And then they facilitate the communication. So you are able to understand, or the criminal or the accused person is able to understand the gravity of what he has done. And the victim is now able to say, this is what I want to remedy the situation. Do you understand? Oh. And that's the aspect. As of today in Nigeria, that is how it applies. So it's not like just a free for all that we don't want we just want to cover up criminal activities, because crime itself is not against individuals, it's against the state. So the state is very, very interested in matters that can actually go through this restorative justice. Somebody stole 100,000. Why do you want to keep the person in the prison if they have realized that, yes, I'm wrong, I've done bad? What can they do? They can pay back, they can apologize, they can do community service, things like that. Yes.
Okay. All right. Thank you very much for that wonderful contribution, Ms. Eunice. You have done wonderfully well. We really appreciate you. So someone is asking about conciliation, example of where conciliation applies. Settlement House is going to be doing an induction, and the topic is on ADR. Is on we are looking at positioning yourself for a global ADR practice. For some of you who want to participate, we have distinguished participants who will take care of this. One of the subtopics that is going to be discussed in the panel is mediative conciliation. And we have someone, a Nigerian lawyer, who has developed the concept, and it has been patented in the United States of America, and is going to talk to us about mediative conciliation. So maybe you can chat me. I'm on the group. Can chat me up, and then I can give you direction on how to do that. So examples. Just to lend my voice to some of the things that has been said, conciliation and mediation, as far as AMA 2023 Mediation and Conciliation Act, Arbitration and Mediation Act 2023 is concerned, is one and the same thing. They make reference to it that in whatsoever name it is called, whether it is mediation or arbitration, whether it is conciliation or mediation or negotiation, whatsoever name you call it, as long as you need a third party neutral that will assist the parties to resolve their disputes without the third party having the power to impose a settlement or impose a solution on them, that is referred to as mediation. So don't be confused. The processes are the same. In fact, the Singapore Convention, also makes that very clear. The same thing, whether you call it negotiation or you call it mediation or you call it conciliation, all of them, as long as the parties do not have the power to impose a settlement, like arbitration, where the arbitrator decides, they are all referred to as mediation. So don't be confused. I believe that you've attended to that particular question. And then one of the questions also here is okay. I think basically these are some of the questions that we have on the platform. if there is any question that does not be attended to by the mentees, please, you can raise your virtual hand and then we'll attend to that. Briefly differentiate. Okay. There is no real difference, so to say, according to the definition that the law has given us between mediation and conciliation. But in Nigeria, conciliation has been replaced with mediation. So we have the Arbitration and Mediation Act 2023. And when you go to the definition of mediation, it includes conciliation or negotiation or whatsoever that involves its process that a third party helps them to disputants to resolve their disputes without imposing any
Nachan, there
solution
is
on
a
them. I
question on
think
the seat
those
of
are
arbitration. Check. There is a question on the seat of
okay.
arbitration.
Yes. Okay, yes, I saw that question. Okay, so Ms. Pa, will you want to use 1 minute to explain to them?
So, when we talk about
Okay,
seat,
we have one more question. Yes. Okay, please, just briefly so that
when we
can.
talk about seat of arbitration, that is different from what we call place of arbitration. The seat of arbitration, we are talking about the procedural law that applies to that arbitration. But when we talk about place of arbitration, we talk about the geographical location. It can even be in a plane. It can be in a hotel. But when we talk about seat, we are talking about the procedural law that applies. And it can be the AMA, that is the Arbitration and Mediation Act 2023. It can be the modern law, but the modern law is not a law. So you must look for a country that has adopted and adapted the model law. It can be the Arbitration and Conciliation Act 2008 of Rwanda. It can be the American Arbitration Act. It can be the London Arbitration Act, Conciliation Act. So you look at those are the laws. And now, how does it imply, so you say apply? What terminology did the candidate use? The candidate say, how does it influence? Okay, how does it influence enforcement? When we talk about enforcement is just like enforcing any judicial judgment or judicial act. And by the time we look at the New York Convention 1958 amended in 2006, sorry, you see that it is particularly for recognition and enforcement. Recognition means we recognize this judgment or recognize this award, and then we enforce it. And enforcement is when the court of the seat puts its enforcement formula on that award. Just putting the enforcement formula on that award is by recognizing it. And then that award can go either enforced by the parties themselves voluntarily or enforced through a bailiff or through a notary public. So this influence is very, very important because so many awards have been set aside. They are filed for recourse. If you look at Article 57 of AMA, recourse for setting aside of an award. And then 58 talks about challenge of the award, which, because the seat is not arbitration friendly, because might be the judges in that seat, in that court of that country or that national jurisdiction does not have more skills and knowledge about arbitration. So either as lawyers or as consultants advising parties in their contracts, you have to make sure that seat is properly chosen, because seat can sometimes be the life of that arbitration or the award. Again, is it a jurisdiction that if there is an interim measures to present, the model law will talk about prevent, preserve, and secure the rest. The rest, we call it the status quo, that is the object that is in dispute. Is it a perishable good? Is it might be some goods that they are shipping from Dubai to Nigeria or to Rwanda, and then if that interim measure or order is not made by the tribunal or the court, is going to destroy that good completely. Is it something that in construction disputes, they don't go to change the something, a landslide, might occur and bring down the whole building and cause a very bigger dispute. So you must look at those seats that you can get interim measures from. So that's the importance of seat in the enforcement of an arbitral award. Subsequently, there are still more things detailing, but for now, I think your understanding it's enough.
Okay.
Thank you very much, Ms. Pa, for that wonderful contribution. So as we begin to round up, there is this last question that is repeated. Can you please comment on the application of ADR in resolving human rights violations? You know, ADR normally where the parties are actually looking for a declaration of their rights. ADR will not apply because it will be only the court that will have the power to declare a right, where your right has been violated. But if the matter, there is a violation of your rights, and then you are in court, there is nothing that stops you from actually settling, you know. So when someone violates your right and you are in court, you know, you can explore ADR to resolve the matter. And if the matter has been resolved, let's say police detain you because somebody has reported to police and then you were detained for 1 or 2 days, and then you are claiming 1 million or 10 million damages against the police and the person who is instrumental to your arrest. You can resolve it out of court. If the person say, okay, you're asking for 1 million, let me give you 100,000 naira. Please, we are very sorry for what has happened, and you discuss and negotiate. You may not need to file any terms of settlement. You can agree and come to court and say, okay, parties have resolved their differences, and then you are withdrawing your this thing. So ADR can actually be used to resolve.
Yes. There is a very, very important issue on this question they ask. Very fundamental. And it's a contemporary issue. It is even found in the Nigerian versus P&ID case. You people can go and read the Nigerian versus P&ID case. Recently, we had a rebuttal lecture with Professor Emilia Onyema. She did an excellent job to this issue of ADR in human rights. And her locus cocycus case was the Nigeria versus P&ID, where she said, you know, that case was a case of high state corruption, which the people of Nigeria could suffer a 10 to 11 billion naira lost. So this is a case of human rights under what? Investment dispute. There are so many cases of human rights abuse in state investment dispute where an investor state or a private company comes and contract with a state government, and then they are exploiting in the mineral resource sector. Then the rights of the citizens or the local communities are being violated, and the government says nothing. So now ADR through mediation is bringing us the room where an amicus curiae can rise on behalf of those violated communities or those citizens that their rights have been violated, and then raise because sometimes the citizens don't know where and how to raise the violation of their human rights. So the solution.
Can you mention the name of that? You said
Sorry,
the
sir.
person.
Please, we have to take pictures before continuing.
Okay. So
you say which case?
Could you turn on your cameras for pictures?
Mentees can put on their cameras. Well, you mentioned someone who did extensive work on human rights.
Professor Emilia Onyema. She's a very senior Nigerian professor and also senior arbitrator.
Emilia.
Yes,
Onyema.
Emilia Onyema. Emilia Onyema.
What's the name of the work, please?
She exhausted the case Nigeria versus P&ID about corruption and human right ADR in human rights violations.
Okay. Please, could we have everyone on camera?
She brought in another solution, the amicus curiae, who can raise the rights of the violated communities or individuals that have been violated, either in an arbitration or whatsoever, or mediation, but mediation was the best.
All right. Thank you very much for that wonderful contribution. I can see the hand of Jane Mary.
Sorry, Naja, can I contribute before I leave on this issue of human rights and then all that? Because I think as mediators, we need to be careful and to be aware of the law so that we are not used as a tool to perpetrate fraud. We consider matters that are for public interest. Sometimes people engage in mediation to waste time. Thankfully now with AMA, that the time will not continue to run when they are exploring mediation. But before, people use it to buy time. And by the time they see that the time, because most of the cases are time bound, and by the time the time is gone, they say, okay, we are not negotiating again. And it will now be too late for the claimant to submit a claim. Also in some property matter, like probates, some will come and say that we want to make family arrangement to avoid paying the necessary statutory payments. As mediators, if we have general knowledge of the area where we are practicing, it will help us so that we will not hate parties to perpetrate fraud against the state or any other person. I've done a matter before where they said there was a judgment, but the actual owner of the property was not a party to that mediation. So they said, oh, they had a settlement and they resolved and they did an agreement. They went to court to enforce the agreement and unlawfully chased the woman that was lawfully in their apartment out. Of course, it led to, I'm not even sure if the matter has been resolved now, the matter of Isegu and Olifumlayo, because I was involved in the matter for like over 10 years and multiple appeals to the Supreme Court. So we need to be careful as a mediator or whichever ADR practice that we are into to ensure that we have the right party and we are not aiding parties to perpetrate fraud or criminality.
Thank you very much for that wonderful contribution. Jane, Mary, I see your hand up. Is it a mistake? Jane, Mary, I can see your hands up. Is it a mistake or you want to say something? Jane?
Jean-Marie.
No, all right. It's not a mistake.
Okay, all right. Thank you very much. So as we conclude, I want to thank the mentees for availing themselves for this time. I want to thank the mentors for the time. And in the course of this, the mentorship and the presentation, I've noticed that some people are making reference to conciliation, and I want to draw your attention that in Nigeria, conciliation has been repealed. And the new law we have is Arbitration and Mediation Act 2023. Please take note of that as mentees. So in your slide, you need to take note of that. The issue of whether it is not expensive or not expensive has been addressed. ADR actually works with time, and people actually explore ADR to avoid the time wasted in court. And you cannot actually quantify the amount of time, compared to some of the things that you want to do. Spending 5 years and spending 2 years, maybe 2 months, 1 month to resolve a dispute cannot be compared. So you can say that it is inexpensive rather than expensive, depending on what you are looking for. Big companies and organizations actually have ADR clauses in their agreements. These ADR clauses are clear indication that we have the right to go to court, but we have chosen or decided that we are going to go to resolve our matters privately using mediation or arbitration or negotiation. That is what it is. Now, an issue of enforceability of decision, which I've seen, don't be deceived. a normal agreement between two parties is enforceable as a contract. So where parties come together and then they have a dispute and they agree, that agreement can be enforced first in court as a consent judgment. You can actually enforce it as a contract. In fact, the AMA 2023 clearly states that you can enforce agreements reached during mediation as a consent judgment or consent award, or all of those things. So it is clearly stated now in the law that mediation is enforceable. So the concept of whether it is enforceable or not has been taken care of. Arbitration, we know, is usually enforceable. So those who are being discouraged from taking part in mediation or ADR because it is not enforceable, that era is gone. Please take note of it. The next time you are coming, you should come with your mediation arbitration act. If you do not have, drop a message on your mentorship list, and I'm going to share the mediation and arbitration act 2023 with the mentees so that they can go through it. So just draw my attention to that and I will do it. Balance of power mentioned as one of the problems. ADR, the mediator.
Please also refer them to the Singapore Convention. It's a recent one that also says mediation is binding on parties. The Singapore Convention.
Yes, Singapore Convention has been adopted, has been domesticated by AMA. So you.
Okay, thank you very much, sir. Thank you very much, Settlement House. It's really been a wonderful conversation. Thank you to our mentees and to all the mentors who joined and shared their expertise. It's been
Please, can
wonderful.
I conclude what I'm saying?
Okay, your network went down.
Sophia.
Yes, sir.
Please, can I conclude what I'm saying?
Okay, sir.
Please, can you hear me?
Yes, I can hear
Yes,
you.
we
I can
can
hear
hear
you.
you.
Hello, sir. Your network is bad. We can't hear you. Well, I think if we have
he has the network challenge.
Mr. Nathan has further input.
Can you hear me?
Hello, sir.
Hello?
Yeah,
Can you hear me?
Not really. You are breaking.
Can you hear me now? Hello?
Yes, sir.
Okay, you can hear me. Okay, so finally, can you hear me, please?
Nachan, we hear you, but your network is so unstable. It breaks and then you get frozen at one point.
Okay. So
okay, with the network instability, sir, we could also pass further information to them or also find ways to put it in next week's session. So is that fine by you? Okay. Thank you very much. So we would end today's session here. Really appreciate Settlement House and all the mentors who participated in today's session. It's been wonderful hearing from you people. To the mentees who joined the call, I hope you got enough knowledge. Thank you everyone and do have a good night.
Thank you to the mentors. Good night.
All right. Thank you for your time, mentors.
Thank you so much. We appreciate it.
Thank you so much for your time. We appreciate it. Good night.